The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess from sitting.
Please be seated. Good morning. Ask Mr. Doug Sheehan, the clerk of the appellate court, to please call the 10:30 docket.
The first case on the 10:30 a.m. docket for Tuesday, May 13th, 2025 is appeal number 126555. John Schutt as agent for the owner J.E. Schutt and M.A. Schutt Family Trust versus Sherri Foster versus John Schutt and Studio 605 Renew LLC, Johnson County. Briefs both sides.
May it please the court, John Schutt, appellee John Schutt as agent for the owner J.E. Schutt and M.A. Schutt Family Trust, appearing by counsel Jada Kerr, ready for argument, and reserve 3 minutes for rebuttal.
3 minutes granted. Thank you.
Thank you.
May it please the court. Eric Kraft here on behalf of Sherri Foster, present and ready to argue.
Second case is appeal number 127505, State of Kansas versus Duran Chance Palmer, Sedgwick County. Briefs both sides.
Good morning, Your Honor. Sean Randall of the Appellate Defender's Office on behalf of Duran Palmer, present ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready.
Your Honor, that concludes the 10:30 a.m. docket.
Thank you, Mr. Shima. Will counsel in 126555 please come forward? Sir, you may argue whenever ready.
May it please the court. Again, appellee John Schutt, appearing by counsel Jada Kerr. This is a case, the Schutt Trust owns a home in Prairie Village, Kansas. The trust and Sherri Foster had a written lease agreement that commenced on November 1 of 2018 to July 31st of 2019. This lease had a late fee provision that $20 for each day was due for rents that remained unpaid after the due date, which is the first of the month. Ms. Foster lived at the rental property from November 1 of 2018 to October 31st of 2020. During that tenancy, John Schutt hired her to do some work on some investment properties, and she did help with those renovations. In 2020, she failed to pay rent. She failed to pay rent in June, so March, April, and June of 2020. Now, there was an agreement that was reached that she was current on her rent as of June of 2020, but then she thereafter failed to pay again in July, August, and September of 2020. A 3-day notice was provided in August of 2020, and then a forcible detainer petition under Chapter 61 was filed on September 11th of 2020. This petition specifically asked for late fees. The late fees in the petition were for $1,750 and for ongoing fees which may accrue during the action. There was also an amended petition filed in March of 2022 that also asked for late fees and ongoing late fees during the action. Now, before the district court, there were counterclaims filed by Foster, including a claim for punitive damages. So normally under a landlord-tenant action, you would go to trial within 14 days. That did not happen here. It took from September of 2020 to March 2nd of 2023 for this case to get to trial. And then on May 30th of 2023, the district court issued its journal entry. Its ruling. It was 91 paragraphs and 16 pages, a very well thought out opinion, which is what we're asking the court today to affirm. The district court found that Schutt and Foster had agreed to the terms of the lease. What the district court did was they found that rent was owed $5,700 of rent And then they added late fees for Foster to pay in the amount of $20 a day from the time of the unpaid rent to the time of the journal entry of judgment, which was 1,062 days of late fees for the time of rent, which was $21,240 in late fees. But what the court did was they essentially canceled out each other's judgments. Then they found that Schutt owed Foster for a security deposit. So the total amount that was owed, including the late fees, was, The court then found that Schutt owed Foster $17,868 for unpaid invoices. So what the court did was they offset the judgments, and so a total of $544.98 was owed from Schutt to Foster. So the court found Schutt owed Foster for unpaid invoices. They found Foster owed Schutt for rent and late fees. What's on appeal is essentially the late fees that were awarded. Now, this is a case where the district court carefully considered all of those factors, and we're asking this court to affirm the district court decision. The Court of Appeals found the late fees in this case were unconscionable pursuant to KSA 58-2544. Now, that statute, there's two issues with regards to the Court of Appeals ruling. Number one, they found it unconscionable, but KSA 58-2544B specifically states, if unconscionability is put into issue by a party or by the court upon its own motion, the parties shall be afforded a reasonable opportunity to present evidence as to the setting and the purpose and effect of the rental agreement.
Can I ask you a question? Maybe jumping before we get to the merits, which you're kind of talking about now in terms of what the statute does or doesn't require. But I understood your first argument to be that that there's a question about preservation and whether or not the Court of Appeals panel properly even reached this statutory question of unconscionability, right?
Yes, yes.
And I guess, and the panel relied on a couple of different exceptions, but our precedent, has held that those exceptions do not apply when we have an undeveloped record or the issue requires further factual development. And that seems to be your argument here, that you need more information to rule on unconscionability. But the reason why that's the case is tied to the merits, it seems to me, because the Residential Landlord Tenant Act has this provision that you just referenced that gives you an opportunity to put on evidence before an unconscionability ruling is made, or that's your interpretation of the statute. So it seems like we're in this weird situation where, right, we need further factual development, but the reason why we do is tied to the merits. So don't we just have to get to the merits here as to whether or not at least you had a right to an evidentiary hearing?
Yeah, so the issue, so what we would ask the court to do is to remand it to the district court with regards to that unconscionability issue.
As opposed to saying that the panel erred altogether and even getting there and we shouldn't even go any further?
No, and that was our other issue, was that the issue was not preserved. It's not properly before the Court of Appeals. It wasn't raised with the district court at all with regards to unconscionability and the lease and late fees. Further, in appellant's initial brief under Kansas Supreme Court Rule 6.02A5, you're supposed to pinpoint cite to where each issue is raised in the record, and if it wasn't, why it was properly before the court. That was not done in the initial brief before the Court of Appeals. So our argument was that it was not properly preserved and it was not properly before the Court of Appeals with regards to that issue. Now, it was addressed in the reply brief in the Court of Appeals, with the Court of Appeals reply brief, and that was the case in Estate of Broderick, and the Court of Appeals found that exceptions 1 and 2 from Broderick applied which was, it was a newly asserted theory or question of law arising on proved or admitted facts. And number two, that it was a consideration of theory. The consideration of the theory is necessary to serve the ends of justice or to prevent the denial of fundamental rights. Again, here the issue is this could have been raised under the Kansas Landlord Tenant Act. The unconscionability statute deals with when the leases were made. It is an issue that could have been raised at the district court. Furthermore, what the Court of Appeals did was limit the late fees to when the tenant was in possession of the property, and said, once she wasn't in possession, well, the lease doesn't allow for late fees anymore, which was not the case. There was nothing in the lease that said late fees ended when the tenant left the property. Further, that issue was not raised with the district court, that the late fees should be limited to when the tenant was in possession of the property.
Is there a distinction or any difference between the application of our exceptions to preservation when the issue is raised for the first time in a brief versus a reply brief?
Is there any distinction? Well, just reading the rule as it's written, it says in the appellant's brief.
Right, but the prudential exceptions to issues raised for the first time on appeal typically at least apply when an appellant raises an issue for the first time in their initial brief. I'm just wondering if you found any case law or any discussion about this is somewhat unique in that it's not only that it wasn't raised that it wasn't raised in the district court, it also wasn't raised on appeal until the reply brief.
Yes, that's
And
correct.
does that make any difference?
Well, the first factor is it wasn't raised below, right? So the Court of Appeals, it wasn't preserved for appeal. Then it's just an added factor that it wasn't raised for the first time in the reply brief. I don't have a case on precedent that,
Okay.
I just have the Kansas Supreme Court rule with regards to the briefs. But yeah, our argument was that it was not properly before the Court of Appeals and should not have been heard on that basis. So what the Court of Appeals did was they heard the case. We believe it was not properly preserved and it should not have been heard. But they erred by limiting the late fees for when the tenant was in the rental property, which is, not what the lease did. And with regards, that's the, I guess, legal precedent that is an issue of public importance. In this case, the lease contained a holdover provision. Now it was expired, but under Kansas law, as cited in our supplemental brief, when a tenant holds over with the consent expressed or implied of the landlord, the law implies a continuation of the original tenancy upon the same terms and conditions.
But isn't that the whole point, going back to what you said, is that in the lease, it didn't specifically say that it was limited to, that late fees would not accrue once the person moves out?
Yes,
Okay.
the lease.
But isn't that the whole point, that literally under that lease, the late fees never stop accruing? It could be 40 years. And if you haven't paid the rent that's due, and I don't know whether you subtract the late fees first, whether it's like a credit card where you do the interest first or your mortgage, but this, under the lease, the late fees could accrue for the rest of a tenant's life. Isn't that true? I mean, that's the whole unconscionability argument.
So chapter 61 is set up so that does not happen, right? Under KSA 613807A, a forcible detainer action is supposed to go to trial within 14 days. Okay, that's in 14 days after the appearance stated in the summons. So once you have that trial, the late fees are determined, at that date. And so that just didn't happen here. It took 2.5 years for us to get.
But where does it say that once judgment is entered, if you don't pay on the judgment, aren't late fees still accruing under that lease?
So normally and my time's almost up, but in chapter 61, so you have the trial, the late fees are in the journal entry. And then after that journal entry, it's post-judgment interest. So, but here we didn't have a journal entry instead of going to trial.
My question is that under that lease, isn't it ad infinitum? Late fees continue to accrue even after, I don't understand I mean, isn't that the whole point? That it's unconscionable because late fees never stop accruing, no matter if there's a judgment for the old late fees, but late fees will still accrue under your position.
So the position of under chapter 61 is once there's a trial, I mean, the late fees stop accruing.
Where does it say that?
It doesn't say that in the, so it says at KSA with regards to late fees stop accruing.
Yeah.
That's just the normal practice under landlord tenant law is it goes in, the late fees go, so the petition asks for late fees. And once there's a trial, there's a journal entry granting whatever amount of late fees apply. Usually that trial's within 14 days. And after the journal entry, it's usually post-judgment interest.
Right, but that's, the statute doesn't prohibit, I mean, there could be, I mean, under the lease.
Well, when there's a ruling under the petition that terminates that action, and then it's post-judgment interest thereafter.
Then you could file a new complaint saying, and you've never paid these under the judgment, and therefore you need
I think that would be res judicata, because in the petition, you're asking for late fees, accruing $20 a day. Like I said, normally it goes to trial within 14 days, and you have the trial, the late fees are.
You're talking about a practice. I'm talking about the lease, what the lease says. And the statute doesn't prohibit that.
That's a possibility, but that's not really, I guess, in practice how it really plays out in chapter 61.
Well, if it did and late fees continue for 40 years, if those late fees reasonably approximate actual losses, then maybe it's not a problem. But isn't your point that we don't know that because we never had the opportunity to put on evidence?
Yes, that's correct. It was never raised. It was never raised below. So there was never an opportunity to put on evidence with regards to that. And I mean, a judgment's not collectible after 5 years in Kansas. So it's not practicality that can't really be collected in an infinity. There's statutes under chapter 61 that essentially prohibit that.
May it please the court, Eric Kraft here on behalf of the tenant, Sherri Foster. And I would agree with Justice Standridge. These fees could go on forever. And in fact, the limited actions court or the limited action statutes allow a bifurcated proceeding as to possession versus rent. Now, we prohibit landlords from receiving attorney's fees, but a savvy landlord is going to ask for possession, and before the statute runs 5 years later, they're going to file an action and say, I need $20 a day for late fees for the last 5 years. And that's going to cover the expenses of attorneys. We have so many statutes within the Kansas Residential Landlord and Tenant Act that protect tenants. They protect tenants. We can't ask for, we can nullify a settlement that violates the act. We can modify the lease when conscionability comes into play. We can impose a penalty on the landlord for failing to timely reserve a security deposit. I have a page of statutes here. But we can assess $20 a day for 3 years which equates to 128% interest rate on the judgment after the property has been relinquished and after the rent had been paid by the offset judgment.
I mean, the simple question is, why didn't you raise all those issues at the district court level?
Because nobody asked for $21,240 in late fees, Judge. The only things that were asked were $5,700 in rent in the original petition, and I believe $1,750 in late fees in the original petition.
The petition also asked for ongoing late fees, correct?
That is correct.
Okay.
Now, the ongoing late fees were not spelled out, but 2 years later, I believe approximately 2 years later, when an amended petition was filed, the exact same late fees were asked, the exact same rent was asked. $5,700, $1,750 in late fees.
I still don't understand your answer. It seems to me if it's in the original petition for late fees, then it's in play. And so all of your defenses, the affirmative defenses that the tenant would have come into play, and this would be one of them, that you're not entitled to this because it's unconscionable under the law,
That the
late fee.
absolutely, absolutely.
So why wasn't it raised at the district court level?
Because nobody in a limited actions court, there is no pretrial order. There is no final pretrial order that says this is exactly what we're asking for. What we have is a petition that asks for, that is required to say that which the landlord wants. It doesn't say something that the landlord wants. It says it has to specify the amount that the landlord wants. We have a petition that says $1,750 in late fees at the beginning of the action. We have a petition 2 years later that says $1,750 in late fees at the same amount. And nobody addressed late fees at the trial.
So are you saying then that the $1,750 at that point, since that's what they asked for, you didn't believe that that was unconscionable? It was only when the district court raised it from $1,750 to $21,000 that it became unconscionable?
That is absolutely correct. What we did was it was a little bit of rope-a-dope. You lull the tenant into believing they're only going to ask for $1,750 in late fees. And then they get 3 years of late fees at $21,240. Nobody raised the issue of being entitled to $21,240. And the district court put it in its order for the very first time, which is why it was appealed. And this is the sole issue on appeal.
But is the statute, the unconscionability question decided based on the circumstances at the time of formation?
The statute does say that. However, the district court still has the inherent ability under common law to limit unconscionability as it's applied. So if we go back and we find $20 a day is not unconscionable when the lease was entered, but as it was applied to reach 128% interest rate on these fees, on these rental agreement, what we're saying then is the court doesn't have the ability to modify the application of what has become unconscionable, and I don't think the law supports that. I don't think that the law supports that at all. And in fact, if the court is modifying as applied, then KSA 582544A doesn't even come into play.
How would the common law come into play when the statute moves in and describes the various rights that the parties have? I mean, the legislature can pass statutes that override the common law.
Because the common law is not overridden here, Judge. It says that if you want to contest the late fee as unconscionable as written, you have to have a hearing, you have to bring it up. It doesn't say anything about as applied. It doesn't limit the court to saying you can't modify the application of a fee. And in fact, it really specifies that the implication of a lot of these statutes are that the court does have the ability to modify unconscionable actions that result from a trial like this.
So that may,
Go ahead. Go ahead.
you've explained, I think, in response to Justice Biles' question, why you didn't raise the unconscionability issue at the trial court. Why did you also not comply with Rule 6.02A5 by invoking an exception in your brief.
That was my error. I will perfectly admit that. However,
And doesn't our case law say, I mean, we have a line of cases from Williams to Godfrey that basically says litigants ignore the requirements of 6.02 at their own peril.
it does say that, Judge. However, in Russell versus Trainer Investments, which is a 2020 case from this court, the district court acting sua sponte raised an issue with its findings of fact and conclusions for the first time. And this court found that it was raised, properly raised at the trial court level, and pinpoint references by the appellate satisfied Rule 6.02A5.
But that's in a case where the issue was raised. Here we have an issue that wasn't raised.
No, that's a case that it was not raised at the trial court level. The district court, in its findings of fact and conclusions of law, addressed the issue like here for the first time with its judgment. The application of the $21,240.
Your argument is that if the issue is decided, that 6.02 doesn't apply?
No, I'm not.
In other words,
that-
you don't need it. You're arguing you don't need an exception to preservation. Is that your argument?
No, well, no, I think we complied with 6.02A5.
Well, the rule requires you to cite to where the issue was decided.
Yes.
And if your argument wasn't raised below, you have to invoke one of the exceptions to our preservation requirements.
Correct. And
You didn't do.
I addressed the sua sponte decision on page 3 of my original brief, and I discuss it on pages 11 and 12 of that brief, talking
I
about
understand that.
how it was raised.
Do you agree that you did not invoke an exception until your reply brief?
I didn't need to invoke an exception. I didn't feel I needed to invoke an exception because the trial court had raised the issue.
Okay.
How did the trial court, oh, I'm sorry, Chief, go ahead. You were next in line.
No, if you're following up, because mine's.
Well, I was just curious how the how did the trial court raise unconscionability under this statutory provision?
The trial court didn't raise unconscionability.
Okay.
It applied it unconscionably. The appeal was the application of the $21,000 in late fees. And my argument was it was unconscionable. In my original brief, we discussed it in my original brief. An entire section of my brief was devoted to it. An entire section of the appellee's brief was devoted to it. Yet I believe that they've waived the argument to get a hearing for unconscionability to determine whether or not this is unconscionable by never bringing it up when they're arguing against unconscionability.
But the statute, though, wasn't cited until the reply brief.
That is correct.
Okay.
But that is the only statute in the Landlord-Tenant Act that involves unconscionability, mentions unconscionability whatsoever. So we didn't specify the number, but it was discussed. And as being discussed, nobody from the appellee's argument said, but if you do find it unconscionable, you need to give us a hearing. They didn't say that in the Court of Appeals brief. They didn't say that in their suggestions back to the Court of Appeals. It was never brought up until they lost the appeal at the Court of Appeals.
And
I'm sorry.
And nobody asked at the trial court level for reconsideration of the judgment or an amended judgment.
No.
So, as I understand your argument, and stepping back just a minute, because the statute does talk about unconscionable when made. And am I gleaning from your comments that you do not necessarily think $20 a day in terms of the amount is unconscionable, that what makes this unconscionable is the gap in the lease that doesn't mention a termination upon change of possession or any other termination date?
That would be my argument, Judge, because if this were a case that $20 a day were applied for 10 days and we're talking about $200, it wouldn't be here. Nobody is going to appeal a case for $200. Here, however, that was left to run for 3 years and allowed $21,240 in fees, not in rent. That's just fees. And as much as we try to protect the tenants in the landlord-tenant arena, this smacks that completely upside down.
So in a way, you're arguing that there is an argument that it was unconscionable at formation without that limitation in the agreement.
I'm arguing that we don't need to get there.
Yeah.
Because $20 a day, if it were shorter, it wouldn't be an issue. But as it was applied, and I know that in practice, we have a new judge in Chapter 61. The former judge would limit that as a matter of practice. That's what he would do. And it never came up. However, here, there was no limitation. And I also, why until the end of judgment? Why until the judgment is rendered? Why not until the end of possession? Why not until the underlying debt was paid by the offset judgment? It is, had we, again, you could wait for 5 years to sue for the lease and rake in an enormous amount of penalty.
Were the amounts owed to Miss Foster at this simultaneously with the time period when she failed to pay the rent? I mean, when did those
Yes.
accrue and become payable?
When Ms. Foster moved into this apartment, or this house actually, she was also simultaneously hired to be a construction manager for 2 other houses owned by the appellee, as well as to perform construction management on the house that she was living in. So the payments were back and forth. She was submitting bills to the landlord was paying those bills, she was paying her rent. 2020, COVID happened, everything went south. The landlord forgave some rent because he couldn't pay, and he applied it to some of what Ms. Foster owed, but only applied that to 3 months. And after that 3 months, she still could not pay her rent because she was not getting paid for these jobs. So she issued bills. He fired her from these construction management positions. And she was $5,700 short in rent.
So you're driving at what's been nagging at me about this case, which is it strikes me that the district court's decision was a Solomonic decision of a sort.
believe so,
And
yeah.
how does that matter with the issues that are before us? It kind of seems like it maybe should, although I'm not certain that's right.
I think it does matter, and I would encourage this court to address it, because this is Ms. Foster's way of living. She knows the rules when she is performing these actions. She's going to bill him at an hourly rate. He's going to pay her at an hourly rate. Under the Kansas Landlord and Tenant Act, the appellee, Mr. Schutt, knows he's going to be limited as to what he can get. He can't get his attorney's fees.
When you sort of agreed with me, just to clarify, the way I was meaning that is the district court appears to essentially, the district court's judgment appears to me to essentially say, look, neither side has clean hands. You're bickering over all this stuff and you're both at fault. I'm just going to cancel it out. And
equity shouldn't involve itself in a contract matter. If they had both clean hands, he didn't hold that in his ruling. I do believe it was a Solomonic decision. But he changed the rules at the end of the game, is what he did.
So your position is kind of like, you can't do that.
Right.
Okay.
She did the work. He agrees that she did the work. He agreed that she was owed the money that she was owed, yet he imposed an egregious penalty to try to even things out and say, well, I don't like either party. I'm not going to give you everything you want, and he's just going to owe you $550 after all of this. Now, this court has the opportunity to instruct lower courts. I'm out of time, so I will thankfully, unless there are other questions, I can rest.
Seeing none, thank you.
Thank you.
So we, the appellee believes there is no common law exception under the unconscionability statute. The statute 582544 specifically talks about limiting the application of any unconscionable provision to avoid an unconscionable result. So that is addressed in the statute. The issue is with regards to conscionability under the Landlord Tenant Act, it's when the lease is made. It's when the lease is made.
What would you respond to the argument that when the lease was made, the $20 per day was unconscionable because there was the lack of any cap or temporal limit?
Raise it below. It was in the lease, it was in the petition, they litigated it for 2.5 years, raise it in the district court. If that's, I do not believe it's unconscionable as written or when made. However, if the appellant felt that way, raise it with the district court.
Even though the amended complaint, which was 2 years later, asked for the same amount of money?
So
Even though
just
2
practice.
years at $20 a day should have been whatever?
The reason practical, it might just have been lawyering, he had changed the damages provision from $10,000 to $30,000. So with the late fees, it was the same in the petition and the amended petition, but it did say for ongoing fees. So that was very clear in the petition and the amended petition, that it was asked for late fees, asked for ongoing fees. So if the appellant believes it was unconscionable in the lease, raise it at the district court. I would say chapter 61 has provisions, so a situation like this doesn't happen. Like I said, mostly the trial's supposed to go to trial within 14 days. Further, under KSA 613807B, it says no continuance shall be granted unless the defendant requesting a continuance shall file a bond with good and sufficient security approved by the court, conditioned for the payment of all the damages and rent that may accrue if judgment is entered against the defendant. So this really isn't a case about unconscionable late fees in a lease. It's chapter 61 has provisions, so this doesn't happen. In this case, that no bond was paid for the back rent that was owed, that could have been paid into the court.
Now, this happened in the throes of COVID. What was the reason that it went 3 years instead of 14 days?
There was so there was a petition, there was counterclaims. In September of 2021, appellant filed a motion to assert punitive damages. There's another amended petition. So the fault of the delay in getting to trial was both parties' fault, was everyone's fault. There's many, like I said, counterclaims and requests for punitive damages. So the Landlord Tenant Act already has provisions and guidelines in place, statutes in place. So something like this doesn't happen.
Your argument is you can cut off the ongoing damages by posting a bond.
Yes, you post a bond for the rent that's owed, because the lease said until it's paid. And here, the district court, which we're asking this court to affirm, did balance out both sides, heard all the testimony, heard all the evidence, and decided everyone got penalized. Post-judgment interest was assessed, and the late fees were assessed. So both parties had, I guess, consequences from the delay in getting to trial. I think my time is up unless anyone has anything further.
Let me just ask you this.
Yeah.
If chapter 61 talks about the trial is supposed to happen in 14 days, which is supposed to cut off the late fees, then why isn't that kind of a dictate that that you only get late fees for the 14 days? Is it implicit within chapter 61 that?
I don't think it's implicit that you only get late fees for 14 days. It's just a reminder that it took so long to get to trial. So we have ongoing
That's not what
fees
I'm
are-
saying, you know, I'm just saying if you're saying this whole thing shouldn't have happened because there's a chapter 61 says trial's supposed to happen in 14 days and then there would be a date certain when those late fees would end. That's your argument, right?
Or if it's past the 14 days, there's supposed to be a bond posted for the amount of past due rent and damages.
Okay, but you agree with the beginning that it's supposed to be the 14 days. I mean, what you're saying is there's a safety valve in there with this 14 days.
Yes, yes. So here,
So what I'm saying is then why wouldn't that mean that the judge should only impose late fees for whatever time and 14 days?
because they didn't go to trial here in 14 days. They went to trial, took 2.5 years. So the lease
So the safety valve didn't work.
didn't work and there was no bond posted, which would have been the back rent that was due. So both of those things were not,
But the back rent that was due, you know, I mean, then there was the counterclaim that she couldn't pay her rent because he never paid her.
yes, there was a counterclaim, there's a petition, there was counterclaims for invasion of privacy,
Well, I think
punitive
you're
damages.
missing my point, but
Yes.
thank you.
Anything further? Okay, thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. Court will now call case number 127505, State of Kansas versus John Chance Palmer.
Madam Chief Justice, may it please the court? Sean Randall of the Appellate Defender's Office on behalf of Jerron Palmer. Your Honor, I request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As your honors are aware, I've raised 2 issues on behalf of Mr. Palmer. One is whether or not the ultimate killing of Mr. Stokes occurred while the attempted robbery was taking place. And the other issue is an instructional error, which I believe the state has conceded was an inappropriate instruction. So the question would be just reversibility as to what's before this court. As to the first argument, I think what this court has to begin with considering is when the attempted robbery in this place concluded and when that was done. This court's defined robbery as completed when the taking of the property is done. And an attempt would be obviously any overt action towards the commission of that offense. And so my argument would be that the attempted robbery in this place was done whenever Mr. Palmer and his accomplices stopped taking any overt actions to take the property from the apartment residence. What you have in this case, I believe, would be that the testimony was that either Mr. Palmer's brother or the other accomplice that he was with went towards the back of the residence while Mr. Palmer stayed in the living room. There was some banging on the bedroom door in which 3 of the apartment residents were in and they had locked the door. And there was then a shot that was eventually fired from one of the apartment residents through the door. It did not hit anybody. And at that time, they all left and fled the residence. It was only then at that point that Mr. Palmer or his brother or someone, one of the accomplices, fired the shots into the apartment, one eventually striking Mr. Stokes and resulting in his death. So my argument is that at the time that the shooting and the firing took place, the attempted robbery had been concluded. They were no longer.
Where have we ever said that in the context of a felony murder?
Well, Your Honor, what you've indicated.
You're really trying to pinpoint something that I don't think we've said before, right?
Well, of course, Your Honor. I would admit that there are plenty of decisions that indicate that this court has never indicated that it has to occur during the commission or during the attempt. But I think what we have here is a very distinct situation. And when we look at the felony murder statute, I think there's only three ways that someone can be guilty of that. There's a killing that occurs either during the commission of an inherently dangerous felony, during the attempted commission of an inherently dangerous felony, or flight from an inherently dangerous felony. He was not charged for killing someone during the flight from an inherently dangerous felony, and I would argue that attempted aggravated robbery is not an inherently dangerous felony. And so I don't think if the legislature has specifically said, look, flight from an inherently dangerous felony, that means flight from an aggravated robbery, but it does not mean flight from an attempted aggravated robbery. And so if we have the legislature delineating that, I don't think we can try and now use res gestae or some other mechanism to say, well, the fleeing was taking place, but that's part of the attempt. And so we're trying to backdoor it in, or I think that's how I would argue it. You've got an attempted robbery that they terminate. They stop trying to take any property. They stop trying. They don't make any demands. There's no allegations that as they're running away, they're saying, still give me property, or that they're attempting to take any property. They're done. They've stopped. They're fleeing. They're running. But that's not how it was charged by the state. That's not what the statute allows. And I don't think that we can now try and say, well, we're using fleeing, but not under the statute, but under res gestae as part of the attempt. And so I think when you've got a cessation of any overt acts towards trying to take any property, you've got the cessation of the attempted robbery, and so that the shooting did not take place during the attempted robbery. I think that also kind of leads into whether or not there's, obviously, I don't believe that res gestae, specifically the fleeing or the running away or the shots that were fired at that time. I don't believe that, again, res gestae, saves that. But if this court were to find that, I've also argued and would continue to argue that the shot that was fired by the apartment resident would be an extraordinary or intervening circumstance that broke the causal chain between the attempted robbery and the ultimate killing of Mr. Stokes. I understand kind of the reaction against that. I know there's longstanding case law that talks about when you commit a robbery, you're a potential assassin, and here's all the reasons why, because these things. And I think when you look at that language and you look at the reasons why that are submitted by the court, you can really kind of lay those factors out or those reasons for four things. I mean, it says either to defend yourself, to defend a friend or a loved one, to actually use the gun in the effectuation of the crime, or to evade pursuit or capture or something along those lines. I don't think we have here, and it says that those are the four reasons why attempted robbery and why a person who engages in attempted robbery, that death or harm or violence is foreseeable. It says it because all of those four things are easily foreseeable. But in this case, I don't think we have any of those four things to support the foreseeability. The gentleman who fired the shot did not know whether or not the person on the other side of the door was armed, did not know whether or not a robbery, I think, was taking place. I mean, he had been told by his girlfriend, hey, there's these three guys here, maybe, don't know what's going on, but he's not, I believe, defending himself or defending a loved one. Mr. Palmer certainly never used the gun, I think, to effectuate the robbery. And there's no testimony that anybody chased or gave pursuit or anything to that effect to indicate that he used the gun to effectuate that escape.
It was effectively a home invasion, right?
I mean, effectively, yeah, I would agree with that.
I mean, I guess I don't understand why that's not foreseeable, that an occupant of the home that is being invaded would take force against the perpetrators?
Because I think as I've read the case law regarding that foreseeability, Your Honor, it seems to be that it's foreseeable because someone will attempt to defend themselves or a loved one. And so just the fact that your home has been invaded, I'm not going to sit here and try and mince as to whether or not that does or does not. I suppose I shouldn't, but I don't believe he was acting in the defense of himself or another. I don't.
You're just trying
He
to.
did not. I'm sorry, Your Honor.
Oh, no, I didn't. I interrupted you, but it sounds like you're suggesting you're just trying to tie it factually to the rationales that have historically been given in those decisions.
That's correct. That is correct, Your Honor. And the reason why we bring up foreseeability is because that's how this court has traditionally defined extraordinary, as meaning it's something that's unforeseeable. And so if the facts in these circumstances don't line up with the foreseeable uses, I would argue then that it's unforeseeable and thus extraordinary. I don't want to prevent or take too much time focusing on this issue without having the opportunity to discuss the second issue, which is the instructional error. I believe the state has conceded that it was an inappropriate instruction and that it was given in error. But there is some disagreement between the parties as to whether it was preserved properly or how it was raised below. I think if I were to understand the state's argument, it seems to claim that any objection that was raised by Mr. Palmer below during the instruction conference was an objection on factual appropriateness, and that the argument now raised here to the court is the legal appropriateness of the instruction. I would disagree with that contention. I believe he said we don't believe the evidence supports the giving of this instruction, and I believe the way that can be viewed as both a legal and factual appropriateness objection, Your Honors, would be that if the burden of proof has been impermissibly lowered by the state, then then the argument about the evidence not meeting that would be that perhaps if the appropriate burden was given, then legally this would not be this instruction would not be appropriate. But I think we're wading perhaps into the weeds, because I think regardless of whether this issue was preserved or not, and if this court were to find that it was not preserved, I think we still meet the clearly erroneous standard. What we've got is competing jury instructions with multiple mens rea definitions. You've got one that defines intent, and you've got another one that defines or equates it with foreseeability. And I think that when you're having multiple jury instructions that give conflicting definitions, especially when they're relating back to robbery, which was related back to attempt, which was related back to the felony murder, when they're all read together, that we have a substantial likelihood of confusing of a confused jury when trying to determine exactly what intent was or was not required. And I think if they had been appropriately instructed, I believe that the verdict and the outcome of this case would have been different. I know that we have testimony from one person, which was the accomplice who was certainly part of this and certainly went to the back of the bedroom, and who ended up getting a deal for 5 years, who indicated that the plan took form in the car ride over to the apartment. And that's what you've got as far as, this alleged intent to engage in it. But I think when you look at the other evidence that was submitted by the people, because the residents of the apartment, my client didn't testify, so these are all things that were said from the other residents in the apartment. But I mean, you've got, I think the evidence established that either my client's brother or the other accomplice were the ones who went towards the back of the residence. You've got the testimony that I believe my brother's client was the one who likely pushed open the door. You've got the only other resident who was in the living room where Mr. Palmer was allegedly standing, who testified that he wasn't even sure that a robbery was necessarily taking place. You've got a lot of things, I believe, that this court can look at to determine whether or not there was intent that the jury could have taken into account if the burden had been appropriately set where intent was, rather than just this general language regarding
Even though
foreseeability.
the intruders wore masks and your client had a gun,
There is
there's no intent to. I don't track your argument about there not being enough evidence that the jury could decide against you.
I'm not, I guess I'm not disagreeing that there isn't there isn't some evidence. I'm disagreeing with that if the jury had taken that evidence also into account with the other evidence, that I think they could have reached a different verdict, Your Honor. As you specifically mentioned the fact that they were wearing masks. I believe this occurred during the COVID timeframe, and I believe it was discussed on the record that it wasn't necessarily uncommon for people to be wearing masks, you know, when COVID were taking place. There was no discussion that this was a ski mask, you know, or any testimony of that. The only testimony about a firearm, I believe, was there was one of the apartment residents who kind of stuck her head out of the bedroom and saw what was going on, and she described that she had seen a firearm in my client's brother's possession, and I don't believe there was any testimony, and I'm sure the state will correct me if I'm wrong, that my client was necessarily waving the gun around or pointing it or shooting it or threatening anybody with it. And so when the court is pointing out the fact that there was masks and they had a gun, that clearly they must have had the intent. I think there's other circumstances that the court and the jury, you know, could consider that would have led to a different result. So I obviously have exceeded my time, but will stand for any further questions that the court may have at this time. Thank you, Your Honor.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. In April of 2021, the defendant and Brecken Elliott picked up the defendant's brother Easton, and they headed out under the initial auspices of going to buy some marijuana. But along the way, a plan developed that they were going to rob THC vape cartridges from an apartment in Wichita. Two of the individuals involved, Brecken and Easton, knew people that lived in this apartment where they ultimately went. On their way, they masked up, they armed with guns, they essentially shove the door down, knocking one of the individuals inside to the ground. That individual is able to hide behind a couch. There's unfortunately another individual there. His name is Eric Stokes. He ends up stuck in or near a chair there in the living room. As the plan continues along its progression, Easton and Brecken head towards the back portions of the apartment, Easton to an empty bedroom, Brecken to the door, where inside 3 individuals, one of whom had seen the armed robbers come in and told her boyfriend and his friend about it. So the men in that room armed themselves. As the door is being beaten down and starting to give way, one of the individuals in that bedroom fired a single round through the door. It hit no one. At that point, Easton fled past the defendant and Brecken, and in that flight, the defendant doesn't flee. At that point in time, he does not flee. The defendant fires 8 shots in the apartment or near the apartment entry. The defendant is ultimately the last to leave. The defendant was so effective in his shooting that one shot traveled through the living room, through a wall, and hit one of the gentlemen in the bedroom in the leg. It was a very tight pattern, both in where the casings were found and where the aim had been. They flee. The defendant disposes of some of the attempts to dispose of some of the evidence. What we have before us today, and this court has to evaluate, is whether or not the evidence was sufficient to determine that the killing here of the Mr. Eric Stokes, who was stuck in the chair and hit and killed when the defendant started shooting, was that during the res gestae of the underlying felony here, and that being aggravated robbery. The problem that the defendant runs into here, and the entirety of their brief and argument today, is that all they're arguing is for an interpretation of the evidence. And it is an interpretation of the evidence that is contrary to how this court views the evidence in appeals like this, which is this court must review the evidence in the light most favorable to the state, including any reasonably drawn conclusions or inferences that can flow from that evidence. Here, the state has made no secret of the fact that for one reason or another, the charge was narrowed, and in that originally the felony murder included the full res gestae element, but come time for the jury instructions, that element was narrowed to only include the attempt language. Ultimately, at the end of the day, the defendant is simply pressing for, as I mentioned, an interpretation of the evidence. Any reasonable interpretation of the evidence, especially interpretation of the evidence in the light most favorable to the state. The evidence of a murder here was overwhelming.
Counsel, let me focus you on what I'm getting the impression is a popular argument by the appellate defender's office on this, trying to pinpoint a moment in time when the underlying crime was completed, and so anything that happens after that falls into it. Now, I can see where your interpretation of the evidence argument plays in against that. Are there other things that play against that argument? See what I'm asking?
I believe that I do, and obviously I understand you're telling me that you see that our position about the standard of review cuts heavily here, and I think
I'm just saying that when I'm doing columns here,
Yeah.
that's one that I understand you're putting on. I'm just trying to figure out if anything else goes into your column on trying to argue against this notion that with felony murder, we get to look and pinpoint a time when the underlying crime was completed and we're done,
and I think
especially on an attempt.
my best answer, Justice Biles, I think, is that it would become circular, because the question of whether or not the underlying crime is quote unquote completed is a question of fact. And that fact on review must always be reviewed in light most favorable to the state. So it cannot lead defendant anywhere. It is a meritless legal argument in that respect.
Maybe let me ask, I may be asking us the same question as Justice Biles, but under the felony murder statute, the focus is on, a killing during an inherently dangerous felony. Here, it was robbery, not attempted robbery, but robbery. And so I understand your position to be that you probably charged the entire res gestae. I don't recall, but for some reason it was narrowed. But that the state's not forced. These are not like alternative means, attempt, flight, commission. It's really a temporal period, and if it falls within that period, that's a felony murder.
That is absolutely correct, Your Honor. And you are also correct. The state initially charged the full res gestae element as you've described, and the statute is during the attempt, commission, or flight from an inherently dangerous felony. And again, I think it was narrowed here. I can't necessarily say why. It's a practice that I hope ends.
And then do we measure the sufficiency against the statute or against the instruction?
The way that I've briefed it, and frankly, because the instruction is what the verdict had to be based on here, is that you weigh it against the instruction. And I think that even doing so here, there is no question that the killing here occurred during the ongoing attempt at aggravated robbery. I would briefly note is in regards to the extraordinary intervening event not existing, as I noted in my brief, and again, math isn't always my strong suit, but as I counted it, it's been nearly 100 years or more at this point where it's been settled law in Kansas that anybody that is committing a robbery, especially one that's armed, is a potential assassin because they know they may be forced to use that weapon to carry out their criminal act or escape without being pursued or captured. The one thing that I wanted to note in addition to that, as was presented today, it was Justice Wall, you were asking about the fact that this was a home invasion. If anything, the status of the law in Kansas at this point in our stand your ground and our firearms laws and legislation as it stands now, this is extra foreseeable. If you're going to kick down somebody's door and try to commit an armed robbery at a home, it is extra foreseeable that that's where people keep guns. I mean, there's just no question. If there are no other questions on the first issue from the brief, I will briefly touch on instructional error. As the appellant notes this today, the state does concede there was an instructional error here. However, this is not the same result is not dictated as what occurred in Mora. The first thing, as the state points out, I think that the record is fairly obvious that this court must review this instruction for clear error, which is initially different from Mora right off the bat. The state's point in its brief regarding preservation below is the state cannot say that there was at any point a clear objection to this instruction or the language that was used here at all. And second, whatever the objection was when it was made, it was purely factual, not legal in nature. So even if we could stretch any of the objections that were made below to somehow apply to this, it cannot be stretched into the factual realm that the defendant argues on appeal. Then, and the reason that matters is the burden's different. Here, the defendant's burden is he has to demonstrate he has to show that this instruction was clearly erroneous versus and that a jury would have reached a different verdict as opposed to just showing that there's a reasonable probability. And the defendant cannot do that on the record of this case, as I've set forth in my brief. I guess briefly, the one other question is Justice Biles, I think that you had on that regarding an intent and a plan. The state's evidence here was a little more clear. I mean, this was a plan that was discussed in the car on the way over. They do put on masks. COVID times are not walking outside up to an apartment door that no one's expecting you in. Clearly suspicious. They're all armed. They're seen armed. They stash the car and then try to get away. This was planned from beginning to end. And the defendant here was the ringleader. So simply put, nothing that the defendant argues could firmly convince this court that the jury would have reached a different verdict, because all that he's arguing, again, is for a different interpretation of the evidence. And frankly, it is one that the state believes is not reasonable. If there are no further questions, Your Honors, I appreciate your time this morning. And I would ask that this conviction and sentence be upheld. Thank you.
Thank you, Mr. Gillette. Mr. Randall, you reserve 3 minutes.
I only wanted to address maybe a couple things that were hit on during my colleague's argument. There was the assertion that my client was the ringleader of this situation, but I would note that my client is the only one who does not know who lives at this residence or what is taking place at this residence. We had indications that both Brecken and Easton were familiar, had been over to the residence, knew who was there. There was no testimony that anybody had ever met or knew of my client. I would also note that, neither here nor there, because I think what I really want to highlight on, and I think what the majority of you have have been wrestling with is this idea that myself and perhaps other members of my office are trying to argue that there is a terminus or a conclusion at which point the underlying felony has stopped and taken place, and that, you know, any killing that occurs after that takes place, you know, would not satisfy the requirements of the felony murder statute. But and I heard you know my colleague mention, and I think some of your honors have mentioned this idea of res gestae, and I want to go back to that, because res gestae is a court made doctrine. And obviously this court is allowed to do that and allowed to interpret things to give effect, but it can't do so when it contradicts clear legislative directory as written in the statute. And the legislature has made it clear in this context that if you're going to allege that a person is killed during the flight from an inherently dangerous felony, it must be from an inherently dangerous felony, which is defined as aggravated robbery.
Does the statute use the word during?
It does not. It says
That's your argument is you've said that multiple times, that it's during, but the statute just says in, right?
It says in the commission of, I believe, Your Honor, in the commission of, in the attempted commission of.
And isn't there a difference between during, I understand why you use that word, because it arguably creates a tighter temporal zone. But the statute doesn't have that word in it.
No, it says as relevant to the case before the court, it would be in the attempted commission of.
Why isn't in temporally broader than during?
I'm not going to disagree. I suppose that it is perhaps temporally broader, Your Honor. And I believe there's case law here that notes the statute does not say the word during. I think I even perhaps put that in my brief, you know, when I was originally citing it. My contention, though, is not necessarily about the temporal. My contention is that I think the legislature has specified that if we're going to allege that someone was killed during the flight, it must be based on an inherently dangerous felony. And as I've mentioned, I believe multiple times, aggravated or attempted aggravated robbery is not an inherently dangerous felony. And so to try and say, well, you know, the statute says this, but we've identified res gestae as all encompassing in this greater, you know, temporal, you know, time frame. I believe that contradicts the clear intent and language of the legislature in the felony murder statute.
You said that if you're going to allege, you know, a killing during an attempt, but is the state required to even do that? I mean, I know it happened here, but more broadly, in looking at the statute more generally, the state could allege that entire temporal period contemplated in the felony murder statute, don't you think?
I understand, based on your questions, that you had posed that this court doesn't view commission or attempt or flight as alternative means, and so if that's the, you know, operation, then I would have to, you know, submit that it could be. But,
Okay, yeah,
but
I'm not trying to answer that question today, but I understand. Yeah, if it were, that's a separate issue. But setting that aside, I mean, just based on the statutory text, yeah, it appears that it covers a more broad, expansive temporal period.
And perhaps it does, Your Honor, but I think as you noted, and the issue that's before this court is that it was narrowed
Sure.
specifically to committed during the attempted aggravated robbery. See no further questions? Thank you very much for your time, Your Honors. I appreciate it.
Thank you. Thank you to both of you for your arguments today. Court will take this case under advisement. Court is now in recess until 9 a.m. tomorrow morning.